We are going to talk today about unfair terms and business, and is fair enterprise possible? Um, Thanks very much for doing the chat stuff. That's all great, and the likes. And because you smashed that subscribe button, I'm now allowed, because I've got 100 subscribers, to get like my own tailored channel name. So it's like UNMCG. I'm not sure what else it's good for to get 100 subscribers, but there we go. I gather that the next threshold is 1,000 subscribers. Then I can like do YouTube with the mobile phone, but. I don't know if we need contract lectures outdoors, particularly because we're not really meant to go outdoors that much these days. Anyway, let's get down to the substance of the lecture today. As I say, it's about unfair terms and business. And what we're going to be doing mainly is discussing the Unfair Contract Terms Act of 1977, which at the time, and still probably now, was seen as the biggest advance in the ordinary or the general law of contract into business standards and also consumer standards. But as we will see next week, we have a separate Consumer Rights Act to deal with that now. But what I want to do as a starting point for today, and the basis of the argument that I'm going to make to you, is take a quote from a leading decision, which we'll look at in detail properly next week, called Parking I and Bevis in the Supreme Court in 2015. So what this entailed was, a very simple set of facts about somebody going into a parking lot and then getting a big fine for staying in the parking space for too long. But as I say, we'll get to that next week. But what I want to concentrate on is just this very small passage from Lord Sumption and Lord Neuberger. And of course, they're on the Supreme Court, so they're very influential. And they said in 2015 that for most purposes, what we're going to do today, the Unfair Contract Terms Act, was superseded by what is now the Consumer Rights Act of 2015. And as I say, we'll do that next week. So this is an important view because here's two Supreme Court judges essentially saying that unfair terms legislation isn't really necessary outside of consumer relationships. They're saying that for most purposes, we don't really need to have any control on unfair terms outside consumer relationships. And I want to ask, well, is that really true? And is it true that we should do little or nothing for small and medium businesses within the field of contract terms? Isn't it possible to have a system of fair regulation, particularly for small and medium enterprises? And the argument that I'm going to make today is that Lord Sumption and Lord Neuberger are wrong. So I've got three main points. The first is that standards to halt unfair terms are needed for small and medium enterprises in particular. Markets without standards end up being rigged for big business. They are not, as the saying goes, free markets. The second point that I'm going to try and persuade you of today is that there are many examples, and I think I'm relatively secure on this one. There are many, many examples of business cases where the courts have intervened to prevent the use of unfair terms. It's not like Lord Sumption and Lord Neuberger were saying that these cases are suddenly being superseded. However, there is an element of truth, I think, in their argument, which is that court-enforced rights are good only really at creating very loose minimum standards. And it's much, much harder to get sort of a positive system of fair terms regulation through the courts. And so that leads me to my third point, which is that unfair contract term regulation sets a baseline within a broader system of fair enterprise. And that includes public ownership of certain enterprises, particularly where you've got natural monopolies or markets fail. It includes sectoral regulation, for instance, to regulate unfair prices or unfair contract terms, like with your mobile phone contract, it can't go more than 2 years. It used to be 1 year, by the way. And competition law or antitrust law. And if you read the news about what's happening in America right now, Elizabeth Warren's presidential campaign, you'll see that there is a lot of discussion about the reinvigoration of antitrust, or in Europe we call it competition law. But unfair terms regulation is an important part within a free enterprise system, setting the minimum baselines or a minimum standard, minimum floor of rights on which other sets of laws have to build upon. Okay, so what I'm going to do is I'm going to take you through the background leading up to the Unfair Contract Terms Act. And again, it's going to be a big discussion, but I hope it's one that is informative. And then I'm going to go through the different parts of the Unfair Contract Terms Act, Section 2.1, Section 2.2 on no exclusions for personal injury or death, and no property damage. Section 3 on no unreasonable exclusions for breach of contract, and we're going to talk about the all-important reasonableness test that underlies its structure. Okay, so those are the three main points, and that's going to be the structure. I should also say, by the way, we'll take a break, and I think last time, instead of me just leaving a break completely free, if you've got questions as we go along, put them in the chat. So if something is not clear, chuck it in the chat, and I'll have a look. Not sort of while I'm doing the lecture, because then it's a bit hard, but during the break, and of course at the end. I realise I haven't sent you a Teams link. It just occurred to me for talking afterwards, but I can do that in the break, and I will email it around. Okay, so first thing is the background of fair enterprise and the law. The lead up to what we now see as modern economic law or enterprise law, the process that led up to contract law reform, and arguments for and against different kinds of reforms that we've seen historically. So I think a good starting point is to ask, well, to what extent is there a right to fairness in contract? And thinking back to the first lecture that we did this year, remember I talked about this old law that was found in the end of the Roman Empire, the Corpus Juris Civilis, or the Justinian Code, saying that if people sold land and they sold it for much less than it was worth, they should receive what was lacking in a fair price. And this idea developed from the ancient times into the Middle Ages, particularly seen in the great theologian and lawyer Thomas Aquinas's writings called Summa Theologica, all the way back in 1265. He said that there was a right to a just price, and more broadly, you could say fair terms in contracts. And he likened the failure to pay a just price or have unfair terms to something like deceit, like a vitiating factor, fraud or misrepresentation that we saw last term. However, he said that prices, and again, more broadly, fair terms, are not quite like, things that you can define with mathematical decision, but depend on a certain kind of estimate, a certain kind of range. So, he was working in the tradition, or thinking in the tradition, of the Corpus Juris Civilis. If you overpay by a half or underpay it by a half, then this would be a range. But the fundamental point was that there was this idea in early contract law that the basis of contract ought to be just and fair terms. Now, if we fast forward a couple of centuries, I rushed through it at the end of last lecture, but we saw a case called Carter and Bone, an insurance contract decision, and I'll just explain it very briefly now, where somebody who owned a fort around, I think it's Indonesia, Fort Marlborough, went and got an insurance contract against, damage to the fort. And failure to disclose, in Carter and Bone, failure to disclose to the insurance company that there was a high risk of the French, of course it's always the French, of high risk of the French attacking the fort. And because there wasn't this disclosure of the risks to the insurance company, the court held that there was a failure to fulfill the duty of good faith disclosure. So good faith back then meant, having to not just not misrepresent things, but positively state things which could be material to the contractual relationship. But more importantly, a few years later, after Lord Mansfield's decision in Carter and Bone, he said that good faith and even further, fair and honest dealing should be part of all contract law. This was a famous statement in Pawson and Watson. By the law of merchants, all dealings must be fair and honest, he said, and fraud infects and vitiates every mercantile contract. Basic idea is that there's a positive right to fairness in contractual relations. Now, unfortunately for the simplicity of our story, the House of Lords rejected Lord Mansfield's approach that there should be fairness of terms, or good faith and fair dealing should be part of every system or every type of contract. Good faith was limited to insurance, and we didn't really have anything for a while about fairness of terms outside one or two pockets of the law. So, in public bodies, we saw this idea developing. And again, it's useful to bring in here Adam Smith and the Wealth of Nations, so the famous lawyer who became known as the father of modern economics. And as you all probably know, Smith gave this metaphor to us of the invisible hand, where if you leave small businesses like the butcher, the baker, the brewer, to make the goods and services that they provide in competition with one another, then there would be more economic prosperity and it would advance the wealth of nations. Smith famously argued that barriers to trade were a bad idea. They made people poorer. But the thing that people often forget or just don't read in The Wealth of Nations is that apart from small partnerships like the butcher, the baker, the brewer, Adam Smith was very, very skeptical of what we might now call free markets because, and most importantly, he thought that the abuse of power was a serious problem, particularly in the case of corporations. He thought that all corporations should be banned, as they were at his time, without an act of parliament. And he thought that any joint stock corporation, big business, was prone to negligence and profusion because some people were in charge of other people's money, directors handling the investments of shareholders and other stakeholders, and that negligence and profusion would always prevail, and that partnerships were more efficient. He also saw a big role for the public sector, something that we don't always associate Adam Smith now, but was a central part of his theories. So a few decades after Smith's Wealth of Nations, and probably the generation which read and took on board his ideas, in Allnut and English, Lord Ellenborough said that for a warehouse that had a monopoly owned by the London Dock Company, the general principle should be that every person should be able to fix a price that they please upon the property or the commodities that they sell. But, he said, if the public has a right to resort to the premises, in this case of a warehouse, and the warehouse company in this case has a monopoly, then that party must, as an equivalent, perform the duty attached to it on reasonable terms. So what Lord Ellenborough is saying here is that if you've got enterprises that have a sort of public character, and certainly enterprises that hold monopolies over something, and that could be through the law or it could be through economic circumstance, then there was a duty for reasonable terms in contracts. Now, this idea was brought a few decades later to the United States in a famous and controversial case called Munn and Illinois, where it was held that an Illinois statute that said that, I think it was again a warehouse, I could be wrong, but so similar kind of business, a statute said that there had to be performance of the contract terms, for reasonable prices. The Supreme Court held that this state law was constitutional because even though it was a private business, prices could be regulated if there was an effect upon the public interest, directly relying in the US Supreme Court on Allnut and Inglis. And this set off a chain of case law throughout the next 50 or 60 years about in what circumstances exactly things should be classified as being, to do with the public interest or affecting the public interest. And then a secondary problem of, well, if you've already said that something is affecting the public interest, if a business is affecting the public interest, what exactly should count as a set of fair prices or fair terms and conditions, which of course is not such an easy question to answer. Now, a few years later after Munn, there was a much darker side, or a flip side to this line of case law, which doesn't concern us directly today, but I think is important to bring up because it was such an historically massive rupture. And that was a decision called or a collection of decisions known as the civil rights cases, which struck down the post-American US Civil War Civil Rights Act of 1875. Now, this statute, after the North had won the Civil War, slavery had been abolished, there had been the Reconstruction Amendments to abolish slavery and make sure that everybody had the right to vote, regardless of race or color or previous status. This was one of the acts, the Civil Rights Act, which further implemented the post-war settlement, and particularly said that nobody could be barred from housing or from theatres or from transport based on their race or colour. And the Supreme Court, despite the democratic determination by Congress and the legislature and signed off by the president, despite that, the US Supreme Court said the Civil Rights Act of 1875 was supposedly unconstitutional. And it did so on this theory of what later became freedom of contract in the Constitution, a theory, as it put it, that if you had private property, that there was no public interest in regulating who you could do business with. In other words, people could be discriminated against on the basis of race and colour, directly tearing up one of the major planks of the post-war settlement in the United States. One of the most famous dissents was by Justice Harlan that said, if you strike down this legislation, you're leaving people virtually at the mercy of big corporations. And here we're talking about people who want access to public services, right? That could include consumers, but perhaps the same rules could be extrapolated to people who aren't consumers as well. But it wasn't left to develop. And that was, a scar for the next almost a century until Martin Luther King's March on Washington and the Civil Rights Act of 1964. But so the basic point for us is that the Supreme Court was retreating from this idea that there could be too much interference with free markets, supposedly free markets. Of course, this is an inherently dishonest way of framing the problem because on the one hand, the law is granting people private property rights, is granting people the right to set up a corporation or run a business, and therefore should be entitled to say what terms the business is done upon. But nevertheless, we had this idea coming into the law that if you had certain kinds of public monopolies and public bodies, there should be reasonable terms. Now, a different kind of evolution in the history was going on in the United Kingdom at that time. So in the UK, there was much more of a development towards public ownership, and probably that was the case because the UK courts were much weaker or much less interfering in what Parliament did compared to the US Supreme Court, which reserved for itself this incredible right to strike down democratically determined legislation. So a few examples of that, and there are many, include the Telegraph Act of 1868, which nationalised the monopolised telegraph lines that were being laid under the Atlantic and around the United Kingdom, one of the first forms of long-distance speedy communication. And even more, and probably incredible from today's eyes, the Court of Appeal decided in Attorney General and Edison Telephone Company that when the telephone was invented, that this fell automatically within the monopoly over the telegraph lines because it said that telephones weren't really that much different from telegraphs, and therefore the public ownership monopoly by the government applied to the telephone lines. And of course, this is Edison, one of the inventors of the telephone. Another example is the Anglo-Persian Oil Company Acquisition of Capital Act in 1914, which brought, one of the biggest oil companies at the time, 50% into public ownership. Now that is what is BP, British Petroleum, today. And there were many other examples to ensure that there were fair terms through public ownership, fair water rates, municipal ownership of gas companies, and in the 20s, there was the British Broadcasting Corporation. And so this is important not only for people consuming things, but also businesses that contracted with what would otherwise be major private monopolies. So if you're a small business and you want to send telegraph messages, but it's a private corporation setting the terms for your communication, then you're really subjected to any price that they set because there's nowhere else to go. So the British government thought, well, better bring those things into the public sector. So the public, ultimately determined by Parliament, can set what it thinks will be fair terms. And on the socialist side or the Labour Party side of politics, this became an important part of the political platform, particularly represented by Sidney and Beatrice Webb, who we've met before. And they wrote about that in a book called Industrial Democracy. They argued that we should see the whole economy, not as, the sort of misinterpreted, invisible hand free markets that people think Adam Smith was talking about today. But the whole of the economy should be seen as like a stream of pressure. They liken the economy to something like a pyramid, where you've got the consumer at the top, choosing which goods and services to buy, and exerting downward pressure through the pyramid of producers and ultimately workers. So the consumer, free as air, said Sidney and Beatrice Webb, could choose where to shop, and they exert pressure down upon the retailer, who tries to push prices down for the wholesaler, who pushes prices down for the manufacturer. And ultimately, this pressures down and down and down to really low wages for the worker, they said, crushed at the bottom of the pyramid. Now, they, of course, were, thinking mainly about labor law in industrial democracy. But there was this idea that, free markets aren't really free. It's actually characterized by a system of pressure and coercion. It's not the same as duress because nobody's sort of holding a gun to your head or threatening to break a contract. But economic necessity is one of the building blocks of the way that the economy actually worked. So they favored progressive public ownership of enterprise in order to make the economy fair. Now, in the United States, none of that was happening. So for a number of reasons, starting with the Civil Rights Act, and we'll talk about this more in a few lectures, the Supreme Court had basically struck down every single kind of social and economic legislation. And certainly there wasn't much public ownership happening. All of this culminated in the Wall Street crash of 1929, the result, to put it in a nutshell, of the absence of regulation of financial markets, the absence of a publicly owned pension system, and with the Wall Street crash and its disastrous handling, coincidentally by a Republican president named Herbert Hoover, the economy had been left in ruins, beginning the Great Depression. And of course, that's when, in the 1932 election, Franklin D. Roosevelt was elected with a major platform to deliver what he called a New Deal for the United States. And one of the first things that the Roosevelt government said they had to do was pass what they called a National Industrial Recovery Act of 1933. And the key part of this was that all contract terms in the economy, or let's say major contract terms above a certain size, should be subjected to codes of fair competition. So with the economy in ruins and workers having lost their jobs, consumers not being able to afford products, small businesses going bust, medium businesses going bust, the whole economy in tatters. They said, well, we need to rebuild this, away from the sort of laissez-faire mess that got us into the Wall Street crash and the Depression. We need to rebuild this through codes of fair competition. And the idea was that businesses should get together, determine what codes of fair competition should apply to their enterprises, sort of collectively to agree what fair terms there should be for their for their sector. And these would be enforced. After the social partners had determined them, they would be enforced by executive orders of the United States president. And this went not only for consumer goods, but it also went for wages. Codes of fair competition right across the economy. But the Supreme Court had other ideas. So still wedded to theories of freedom of contract or aggressive intervention in what democratically determined legislatures were doing. A case called Schechter-Poultry and the United States, also known as the Sick Chicken case, held that this act was unconstitutional, and it struck it down. It said, more particularly, that there was an unlawful delegation of power, as a matter of public law or constitution and administrative law, to the executive, and therefore it could not be upheld. And so this halted experiment about what a fairer kind of economy could have looked like. It wasn't a sort of right to fair contract terms in law administered by the courts. It was instead codes of fair competition administered through executive order, ultimately backed by the president. And we just don't know whether this would have worked, if codes of fair competition could have produced a more fair system of enterprise. What happened instead is that the United States government started passing slightly different kinds of acts, but what it hoped would have a functionally equivalent outcome. It passed the National Labor Relations Act of 1935 to have fair terms at work. It improved, importantly for our purposes today, antitrust law and the law against monopolies, particularly to combat unfair practices like price discrimination by big businesses against medium-sized and small businesses. That was an act called the Robertson-Patman Act of 1936. And it set about assembling, as I mentioned previously, what became known as the Second Bill of Rights, a comprehensive economic constitution that was meant to ensure fairness for everybody in the country. Now, back to the UK post-World War II, again with a very different experience. We learnt from some of what that the Americans had done, although there was much more of an emphasis continuing on public ownership. So after the Second World War, the Labour Party for the first time won a majority government, on a platform of saying, now that we've won the war, what we really need to do is win the peace. And it put forward a comprehensive system or comprehensive plan for public ownership of enterprise. This included setting up the National Health Service, putting electricity into public ownership, having a common system of public ownership and regulation for water, but also starting, taking from the American experience, a new system of competition law regulation, which was in particularly important for things that were still in the private sector. So to combat big private monopolies, to combat cartels. This was beginning with the Monopoly and Restricted Practices Act of 1948, and more legislation continued over the post-war era, including the Fair Trading Act of 1973, and now all found in the Competition Act of 1998. So if you do competition law, that's the main law that you'll be studying, alongside the highly important European Union legislation, after which UK law is modelled, found in the Treaty of the Functioning of the European Union, Articles 101 and 102. Okay, but then, given all of this background structure, and I know it's a very big picture, but I think it's very important to see what's going on in contract terms. Given all this background structure, what minimum standards should there be within private enterprise, or even if you're a small business contracting with a publicly owned body, what, if any, standards should there be in contract law? And of course, by the 1970s, remember back to a couple of lectures ago when we were looking at the law on reasonable notice of unfair terms. The common law hadn't yet said anything that explicitly regulated the content and the fairness of contract terms. So it hadn't gone back to what Lord Mansfield said in Porson in the late 18th century and said that there was any kind of positive right to not have unfair terms. So that's where the Law Commission comes in. If you don't have public ownership, if you don't have effective, or aside from competition regulation against monopolies and cartels, what should be, if any, the standards of terms in contracts? So the Law Commission in 1975 wrote this report and said, to quote, "We are in no doubt that in many cases exemption clauses, and perhaps more broadly we could say unfair terms, operate against the public interest, and that the prevailing judicial attitude of suspicion, like in cases like Chapelton and Barry or Ollie and Marlborough Court, the prevailing judicial attitude of suspicion, or indeed of hostility to such clauses, is well founded." Too often, the Law Commission goes on to say, all too often they are introduced in ways that result in the party affected by them remaining ignorant of their presence or import until it's too late. That party, even if he knows of the exemption clause, will often be unable to appreciate what he may lose by accepting it. And in any case, he may not have sufficient bargaining strength to refuse to accept it. So that's drawing on the language there of what you can find in Sidney and Beatrice Webb's book, Industrial Democracy, going all the way back to Adam Smith, the importance of bargaining power. And when you have unequal bargaining power, people are in no position to refuse to accept unfair terms, and particularly exclusion clauses, which cancel implied rights. So it goes on to say, the result is that the risk of carelessness or a failure to achieve satisfactory standards of performance gets thrown onto the party who's not responsible for it, or who's unable to guard against it. So exclusion clauses operate often to the detriment of the person who is least deserving or least capable of dealing with the risks that are inherent in many contracts. By excluding liability for such carelessness or failure, trying to absolve yourself of responsibility for your own stupidity or negligence, the economic pressures to maintain high standards of performance are reduced. So this is a crucial part. But what it's saying is that if you have the use of exemption clauses against, for instance, your own negligence, or if you have unfair terms, then businesses don't end up competing on the quality of the products that they are selling or the quality of the services that they are selling. They end up competing by trying to wriggle out of responsibilities, and the standards for their performance will end up being reduced. So if we want to have an efficient economy, which ensures that people produce the best products and services, the control of unfair terms is important. And I'll skip over the next bit, but then it says the cost and practicability of insurance may be factors in determining how liability should be apportioned between two contracting parties. So what unfair terms legislation should take into account, ideally, is when there are risks in contracting, which party is best placed to get an insurance policy against the risks of something going wrong. And that is the thinking that went behind the Unfair Contract Terms Act that we're about to look at now. Okay, so the 1977 Act has a pretty simple structure, and we're just going to walk through the sections one by one. So we're going to start with Section 1, often a good place to start, on the meaning of negligence and business liability. That's often the subject of exclusion clauses. Then the second thing we're going to look at is the one that we've seen before, Section 2.1, on no exclusions for personal injury or death. And then Section 6 on implied terms and sale of goods. Okay, so the first thing is that the Unfair Contract Terms Act regulates exclusion clauses or limitation clauses, more broadly known as exemption clauses. So that is very particular, and as we'll see, it's a bit more narrow than next week in the Consumer Rights Act, which looks at all unfair terms. But it ends up being sort of the same for reasons that we'll get into a bit later. But so the main thing that the Unfair Contract Terms Act targets, and what exemption clauses are often seeking to exclude liability for, is negligence. So Section 1.1 defines what negligence is. Three main things. First of all, negligence is defined as in terms of a failure to take reasonable care as either an express term or an implied term of a contract. Okay, so negligence is the opposite of diligence, and diligence means taking reasonable care. Therefore, negligence is the failure to take reasonable care. And as we've already seen in contracts of service, for example, there's a duty to take reasonable care in the performance of a service. So it could be an express term or it could be an implied term. Second thing is that negligence relates to any common law duty of care. So apart from no negligence being a term of a contract, there could be a duty in tort law. So the common law duty of care is referring to tort law. That's the law of civil wrongs, the non-contractual obligations in the main. And the third main thing that it refers to is the duties in the Occupiers Liability Act. So basically, when you walk onto somebody's property, let's say you go into the supermarket to get a banana or something, or you're going into the supermarket to get a sandwich, who knows, then the supermarket will be an occupier, and you will be considered to be a licensee when you enter the property. You have an implied license, and they have a duty of care as an occupier to you, to make sure that you don't get killed or injured inside. So that's all set out in a statute called the Occupiers Liability Act 1957, which you'll do more of in tort law. Now, then Section 1.3 says that this act is concerned with business liability. So that's liability that could be incurred in the course of business, but it also extends under Section 14 to any government authority or public authority. But basically we're talking about, really any public or private body engaged in the course of business, or as it says there, a public authority. Now, exemption clauses often purport to exclude or limit implied terms or these common law duties in tort and under the Occupiers Liability Act. So that's the target. And the only small exception to note is that Schedule 1 says that it doesn't apply, these rules don't apply to contracts for insurance, for land, intellectual property, company law, or securities contracts. And the reason why the Unfair Contract Terms Act doesn't apply to these things in Schedule 1 is because there is much, much more comprehensive regulation in those areas. It's not that these things aren't regulated at all. On the contrary, they're much more heavily regulated, like in the Companies Act 2006 or the Financial Services and Markets Act for Securities Contracts of 2000. Okay, so now then we get to, I think, the easiest section in the Act and the most straightforward, Section 2.1. Each of the sections deals with a different kind of subject matter, so that's the best way to see it, and this deals with personal injury or death. So really straightforward, it says, a person cannot, by reference to any contract term or to a notice given to persons generally or to particular persons, exclude or restrict his liability for death or personal injury resulting from negligence. Okay, so you can't exclude at all or limit liability for death or personal injury caused to somebody else. So indirectly, as I said before, this is protecting the right to life and the right to safety. You can't exclude or restrict liability for death or personal injury. So, for example, if a business would be liable in tort or contract for negligently killing somebody or negligently injuring somebody, they can never exclude liability towards the victim. So what you do is you ask, would a business or would a government public authority be liable without the contract, or if the contract was silent? And then if there is an exclusion clause that tries to exempt them, then it doesn't matter. It's void. It's ineffective in the face of Section 2.1. So if we look back at past cases, as we've seen before, this would have changed the outcome in quite a few cases. So in Thompson, with the train platform, unfair term is gone. In Chappleton, the courts found a common law remedy, so that's fine. Section 2.1 would have added to the protection but wouldn't have changed the outcome. And in Thornton and Shoe Lane Parking, here you would have had, if the Court of Appeal had got to the point where they said that the exclusion clause was incorporated into the contract, it would have in any case been unfair for the trumpeter injured in the car park. And we see all the same things now also in the Consumer Rights Act 2015. This is what it looks like. Basically, it's exactly the same thing. It just says all the same stuff in a much more long-winded way. We'll come back to next week. But you can't exclude or restrict liability for death or personal injury in relation to consumers either. Now, next section that we have to look at is Section 6. So the Unfair Contract Terms Act 1977, Section 6 says the following. In subsection 1, it refers to the Sale of Goods Act 1979, Section 12, and the Sale of Goods Act Implied Terms Act of 1973, Section 8, on the idea, or on the implied term, that a seller or a hirer has good title to the thing that they are selling. And very simply, Section 6.1 says that any exclusion clause for this, or any exemption clause more broadly, is void. Just can't have it. If you're selling something, you always have to be selling stuff that is yours. Now, Section 6.1a goes further, and it says that exemptions for the Sale of Goods Act 1979, Sections 13 to 15, or the 73 Act, Sections 9 to 11, on goods matching descriptions or samples, or goods being of satisfactory quality, can only be subject to an exemption clause if the exemption clause is reasonable. So Section 6.1, always got to have good title to the thing that you're selling. But Section 6.1a says that if you've got an exemption clause, let's say, for example, over the good being of satisfactory quality, does the pen work after I sell it to you, then that's only effective if the clause is reasonable. So pretty much the same thing under consumer contracts, as we'll see next week. But then the big question is, what counts as reasonable? So this is the axis of much of the Act, the reasonableness test in Section 11 and Schedule 2. So to determine whether an exclusion clause or a limitation clause is reasonable, the court has to pay regard to a series of different factors. Section 11 points to the resources that are available by the business using the exclusion clause or the party that they are contracting with for covering liability, and in particular, how far it is open to either party to get an insurance policy to cover any risks. For instance, for an implied term of, that the pen doesn't work or the automatic vending machine doesn't work. And in Schedule 2, we've got more factors for what we take into account for whether something is reasonable. Schedule 2 sets out 5 main things. So first of all, and probably most important, we look at the relative bargaining power of the parties. So if you've got a big business with a lot of bargaining power, bargaining with a small business with not very much bargaining power on a standard term contract, or standard form contract, and the big business is using exemption clauses all over the place, then that is probably going to mean that the exclusion clause is unlikely to be reasonable. So one main thing is insurance. A second main thing, and perhaps the most important, is bargaining power. We should also look at the alternatives that either party has on the market to find different products or services. If you've got loads of choice and the market's working really well, then probably the use of exemption clauses might be okay. But again, depending on bargaining power and insurance, we weigh all these things together. We look at the terms transparency in the contract. If it's hidden down in the small print, probably less reasonable. We look at whether the compliance with the conditions of the contract are practical. And last, we look at whether the goods are made to order. And I think that last one indicates that, if you've negotiated over the terms of the contract and the goods are made to order, then it's more likely that you've got more bargaining power, more negotiation power, and therefore the terms, including exemption clauses, are more likely to be reasonable. Okay, but so the basic point, I think, has got to be that bargaining power matters, transparency matters, who can get an insurance contract matters. All of these things get weighed up in determining whether an exemption clause, an exclusion or limitation clause is reasonable. The Act, by the way, doesn't explicitly say that we look at Schedule 2 in determining, for all purposes of the Act, whether or the items in Schedule 2 for the purpose of the reasonableness test. But the courts have said a number of times, including in this case in Woodman, just after the passing of the Act, that Schedule 2 is relevant for all of the sections of the Act. Okay, so now leading case, very soon after the passing of the Unfair Contract Terms Act, is one that we saw a bit of before, George Mitchell and Finney Lock Seeds. Really simple set of facts. George Mitchell bought some cabbage seeds from Finney Lock Seeds, and there were some limitation clauses in the contract. Clauses 1 and 2 limited damages for defects in the cabbage seeds to the price paid. Yeah. So you buy lots of cabbage seeds, and if they don't work, the only money that you can get back for the failure of the cabbage seeds is the price that you paid. But for farmers, this is really harsh, because if you've got loads and loads of fields with cabbage seeds and they all fail to grow, then that means that you're not going to be able to sell anything after the harvest. That can mean a lot of money lost in profits, and that is precisely what happened here. The cabbage crops failed. There was £61,513 in lost production. So the question was whether clauses 1 and 2 of the contract were void given the unfair contract terms legislation. Now, in the Court of Appeal, Lord Denning, dissenting on the reasoning, held that the limitation clauses did cover the defective cabbages as they stood. The other judges said something funny. They said that because they never grew into cabbages, they weren't ever really cabbage seeds. But regardless of that, Lord Denning said that now we don't need funny constructions of what the contract terms were. That was where he was talking about interpreting the natural meaning. And he said that the main point was that the terms were unfair under what is now Section 6 and Schedule 2 of the Unfair Contract Terms Act of 1977. And Lord Denning was upheld in the House of Lords. They unanimously uphold Lord Denning's dissent, and they said that the clause in the contract did concern cabbage seeds, and what was sold fell within it. The limitation clause was unreasonable, primarily because the seller was dealing with many, many customers, lots of people buying cabbage seeds, and the seller was therefore in a better position to guard against the risk of the cabbage seeds being duds and get an insurance policy to cover any losses that resulted. And this is maybe not immediately intuitive, but makes a lot of sense. And it goes like this. So if you've got one seller selling to, let's say, 10 or a dozen or 100 different buyers, then when you're thinking about who's best placed to get an insurance contract, well, you could have one seller getting an insurance contract to cover against the risk of the cabbage seeds being duds, or you could have the dozens or hundreds of buyers each getting an insurance contract to cover against the risk. Now, it's very simple. One insurance contract is probably cheaper, and you can probably get a better, one big insurance contract, you could probably get a better deal than lots and lots and lots of insurance contracts. So that's going to be a lot more time for a lot more people, and probably the costs are going to be higher. So that's what the House of Lords is taking into account in determining who is best placed to get an insurance contract. Here's Lord Bridge on the reasonableness test. He says that the courts must entertain a whole range of circumstances in determining what is reasonable. And sometimes he says there's going to be room for a legitimate difference of judicial opinion. So the appellate court, he says, should be deferential to what the court of first instance decides when they determine whether a clause is reasonable or not. So when something goes to, maybe it's the county court, but usually for a substantial claim over a few £1,000s to the High Court, they're going to look at all the facts in detail and decide whether a clause is reasonable. And appellate courts should be reluctant to interfere with courts lower down. Give the first instance fact-finding court more discretion to determine what is reasonable or not. So that is George Mitchell and Finney Lockseeds, and I think still is probably the leading case. But then we've got, and I see one person has very astutely already asked in the chat, we've got a question about what might happen to older cases, and particularly a case like Lestrange and Graucob. And absolutely, if we had exactly the same set of facts today, it would be very different. So I think that this is how it would go, and Andrew Burrows in his casebook on contract roughly thinks the same. If we had the same set of facts as Lestrange and Graucob, where the cigarette vending machine is sold to the small business and they have this exemption clause saying, well, if it doesn't work, you can't do anything. The first step would be to say that this breaches the implied term of goods being of satisfactory quality under Section 14.2 of the Sale of Goods Act 1979. So that is definitely the case. There's an implied term and it's breached. The second thing is we would go to the Unfair Contract Terms Act and we would say, or we would ask, is the contract term which exempts liability for failure to provide a machine of satisfactory quality effective given Section 6? And the answer to that under Section 6.1a, and then looking at the reasonableness test in Section 11 and Schedule 2, is probably no. In fact, it's almost certainly no, it's not a reasonable clause. And we get to that by saying, perhaps, well, maybe it's not very transparent. You'd have to look at the contract document. But mostly, the bargaining power of the parties is probably unequal. Lestrange is dealing on a standard form contract. They're just asked to sign the document. And the bargaining power of the parties is not equal, and therefore it's less likely to be reasonable. And by the way, just as a footnote and also for next week, we would be doing this today arguably under the Unfair Contract Terms Act because Lestrange is acting in the course of business. She doesn't therefore fall under the Consumer Rights Act of 2015, as we will do next week. Okay, now I think it might be useful before we take a break to quickly outline how you might go about this in a problem question, because I know that we often do lectures right throughout first year, and it's not always spelt out what the best way is to deal with problem questions or the best structure, particularly given that many of you will have just had the shock of doing your mid-sessional exams. And it's a question that I get asked all the time. So let me just briefly summarize how you would go about, a question like, well, what would be the case today on the facts of Lestrange and Graucob? How would you structure the answer to a good problem question or answer a good problem question well? I think that what is called the IRAC method is the best one. So that is that we go in a set order for every single claim. We look at all the different claims in a problem question. So there might be 3, there might be 2, there might be 4, but isolate each claim one by one. And that's the first thing. How many issues are there? And then within each, you should follow the following pattern: issue, and then explain the rules, and then apply, and then conclude. So the first thing would be a question like, or a statement in answer to the question, which would be something like, Lestrange could have a claim for breach of contract if an implied term cannot be validly excluded under the Unfair Contract Terms legislation. Okay, so that is stating as quickly as you can what the first issue is. And then you would go on to explain the rule. So that's the next step. Don't sort of start summarizing or repeating facts in the problem question. Never do that. Never, ever, ever repeat facts, because life is too short and we don't have the time, particularly in exam. And also everybody knows what the facts are anyway in a problem question. So the next thing after stating the issue is that you explain the applicable rules. So here it would be the Sale of Goods Act in 1979, section 14.2, requires that goods are of satisfactory quality. And then you can elaborate on this. Of course, what I'm saying here is very short. And you would explain the other rules. The Unfair Contract Terms Act 1977 prevents any exclusion unless the exclusion is reasonable. And that is under Section 6, and then you would explain Section 11 and Schedule 2. And what you would want to do as much as possible is quote the statutes, explain any main cases, like if you wanted to summarize George Mitchell, that's a big case, very quickly explain the facts in a sentence. And then as much as you can, explain the reasoning by quoting what the judges have said. So ideally, you want to write just like a judge in a judgment, or the best articles or law reviews that you read. And if you've got a conflict of authorities, well, what you've got to do is you've got to argue which one is better. So if you've got a House of Lords decision and a Court of Appeal decision, and they're saying conflicting things because Lord Denning has said something intelligent and the House of Lords has said something less intelligent, then you would argue about which one we would prefer. And of course, it's the doctrine of precedent, and higher courts beat lower courts. But if there are persuasive principles, then you've got to argue for what you think is right. And then what we do after we've explained the applicable rules is that we apply those rules to the facts. So again, we're not repeating the facts, we're applying the facts. And for example, it would be, here the machine was not of satisfactory quality and bargaining power is unequal. And then we get to the conclusion. It follows that there's a breach of contract and the exclusion is invalid. So issue, rule, apply, conclude. And if you follow that every time, and if you do all the quoting, then you can't go wrong in an exam or indeed in any piece of written work. Now, let me also say, I think I've got time before a break. Let me also say something quickly about how to write an essay. So I think that often in exams doing essays is a very good idea. Don't just stick to problem questions, because you have more scope to show your creativity in essays. And it shows, that you're thinking about broader policy issues, which you have less room to do in problem questions. Not no room, but of course you're trying to advise and give an answer. So in essays, what you need are three things: style, structure, and substance. The substance is the law, how well you do the law, just like in a problem question, as I explained before. The style is you, so you should develop, a persuasive written style. And the way that you do that, I think, is that you just read lots and you follow the judges or the authors that you like best. Perhaps most the difficult thing, which takes a long time to learn, thing that doesn't come naturally but has to be done through experience and a lot of thinking, is the structure. And the best structure I know is from an old Roman text called Rhetorica ad Herennium, which is basically advice on rhetoric for Mr. Herennium back in, I think it was the 1st century AD. And the Rhetorica ad Herennium says that, well, there should be a few main parts for how you structure an essay. The first thing is that you obviously introduce, but that doesn't mean just sort of restating the question. That means introducing what your argument will be. Start off with a general statement saying why this is important, why this topic matters to people, and then summarize what the main steps of your argument throughout the body of the essay will be. So you're actually saying what you want to persuade people of, what you're arguing, pretty much as I do in these lectures. And by the way, as Lord Denning did in numerous cases, Candler and Christmas is a famous one, or Jonathan Swift in the Modest Proposal. Then in the body, set out the background to the argument, set forward your positive arguments, and then anticipate and rebut counter-arguments. You could do that in a short essay as those chunks: background, positive arguments, anticipate and rebut. Or you can start to mix it up, and you can have, in long essays, you need to do this, bits of both for different issues. There's no right way to do this, but learn a model and try to follow it. And then finally, you should conclude your essay by pleading the urgency of the case. So that's going further than just restating your argument, but trying to ram home why you think it's really important. And again, there's no right way of doing this, but if you follow a model like this one, and do read the Rhetorica. I think that you really can't go wrong. Now, I just want to finish before the break on bringing up what I think is the most unfair term ever. So, if we applied this legislation, the Unfair Contract Terms Act of 1977, to an old classic, a story, that is in many, many linguistic traditions, but here's a copy of Goethe and Faust, then I think that you would say that the term in Goethe and Goethe's Faust of selling your soul to the devil would definitely be unfair. So, for example, in Faust Part 1, Mephistopheles, who's the devil, says, "In this world I will bind myself to cater for all your whims, to serve and wait upon you." So this is a service contract, right? But when we meet in the next world, sometime later, wages in the same kind will then fall due. And of course, this is a completely unreasonable term, obviously violating the Supply of Goods and Services Act of 1982, because the service contract that Faust is binding himself to is for an unlimited period, whereas the devil is binding himself to serve Faust for a limited period. But, Faust doesn't really know what he's doing, and he says, "Oh, the next world, that's no great matter to me." And of course, that was a very bad decision. And it's even signed as a document with a drop of blood. But definitely, I think modern unfair terms legislation would deal with this. But also, just to end, is that I think that Faust also contains some very good advice on writing essays and problems. Mephistopheles, again the devil, says that we'll teach you that your process of thinking, instead of being like eating and drinking, spontaneous, instantaneous, free, must proceed by 1 and 2 and 3. So I think this is the point about good structure in problem questions in essays. It's not just free flowing. You have to think carefully about how to get your points across. And when you have good structure, one of the best things that it can do is that it can appear more persuasive. This is something that I am continually trying to learn. It's something that I practice and think about all the time. And you can never, I think, do it too perfectly. So it's something to work on with every essay. But it's very good advice, and the devil, of course, was an excellent lawyer. Okay, so let's take a break. So let's make a start again, and there's some great questions down in the chat. Thanks very much for asking. I'll just rattle through those quickly before we get on to the next sections of the Unfair Contract Terms Act. So the first question is, isn't it unfair to hold the seller of seeds liable just because they didn't grow, unless the seeds were known to be unable to grow or from some other form of fault on the seller's behalf? And I think that's a really good point. So what matters is the seeds are defective. So there's lots of reasons why the seeds might not grow. It could be bad weather, right? But what matters is whether the product that is being sold is defective. And that means that they're not of satisfactory quality. And that means that there is a breach of contract because of the implied term. But very good point. Then the second question is, would we avoid speaking about incorporation interpretation and just go to the act? Well, I think the answer to that is, like a lot of things in law, is it depends. So if the act is the most obvious way to deal with a problem, then it probably makes sense to start with that. I think as common lawyers, we often seem to want to apply the common law first and then statute later. But I think it's probably best to start with acts, particularly if it's section 2.1 or section 2.2. But then you might go, well, even if that's wrong, so even if there is a claim under the act, there could be a solution at common law. I mean, or you could do it the other way around. You might say that a clause isn't incorporated at common law, and then you never need to get to the act. But you say, well, even if that's wrong, this is going to be the position under the act. And in real life, of course, if you are dealing with an unfair contract term, you're advising your client, you want to look at every possible claim. So then the third question is, could you clarify the concept of an insurance contract from Lord Denning in the Finney Lock Seeds case? Well, I think if I've understood that rightly, that's very easy. So you could get an insurance contract for crop failure, right? Very common. In fact, under the United States Agricultural Acts, which is the equivalent of our Common Agricultural Policy, in Europe and in the European Union, and also there's the Agriculture Act in Britain, although I think that was still part of the Common Agricultural Policy. In the States, there's a right of government insurance, so that's what that is. Then would you recommend reading all the cases on the lecture outline document in full? No, because that would take you a long time. What you want to do is you want to read everything in the case book, right? So the main case is in the case book. That's really the core. And when I put asterisks on the lecture, what that means is I want you to have a good look at that, ideally in the case report. But I think it's fair to say that nobody sort of reads, from the very start, first sentence, right down to the end of a judgment, unless you're doing it, for, I don't know, unless there's some really important reason. But even if you're working on a case, I'm not sure that you'd always do that. What you need to do is get a sense for the facts, and then you want to go to the important bits of the reasoning. But yes, reading the law is very important. And just a couple more adding to. That's cases with stars. Yes, and last question. They'd sent the wrong. Oh, that's not a question. That's just a statement. They'd also sent the wrong kind of seeds. Okay, so that's it, and you should have a Teams link. So after the lecture, I will talk to you there if you have got any more questions or you want to chat. Good. So now let's get on with the rest of UCTA. So what we're going to look at now is section 2.2, which relates to property damage. So all the sections sort of target different things. Section 2.1 for death or personal injury. Section 6 for implied terms. Section 2.2 is for property damage. And then there's section 3, which is about exemption clauses for breach of contract. And section 13, which is the anti-avoidance provision. And I think we actually do that before section 3. Okay, so this is section 2.2. In the case of other loss or damage, a person cannot so exclude or restrict his liability for negligence except insofar as the term or notice satisfies the requirement of reasonableness. So there we are with the reasonableness proviso again. So this is for property damage primarily. It means that restrictions on liability for property damage are only effective if they are reasonable. So it's not like section 2.1 where everything's banned. You can have restrictions, but they've got to pass the section 11 and schedule 2 tests of reasonableness. Now then, on top of that, let me explain section 13. This is the anti-avoidance section. So if something has the effect of exempting a party from liability against a victim of property damage or something else, then the verbal form of the clause is irrelevant. So it doesn't matter what the legal or verbal form of a contract term is. If the effect is the same thing as exclusion or limitation of liability, then section 13 says that it's caught anyway. Now, this rebuts an argument made in the run-up to the Act by Coote in exception clauses and argues that some clauses define a contract's primary obligations restrictively, or if a clause does that, then it's not really an exemption clause, it's a duty-defining clause. And this was a way of saying, well, controls on unfair terms shouldn't go too far. But section 13 doesn't follow this approach. It looks at what the substance of an exclusion clause is, and it asks whether the obligations would be, or what the obligations would be in the contract, but for the objectionable term, or but for the exclusion clause. Okay, so it says this in the text of section 13. To the extent that this part of this Act prevents the exclusion or restriction of any liability, it also prevents the making the liability of or its enforcement subject to restrictive or onerous conditions. So remember the Uber case in Canada, Uber and Heller, saying that enforcement of any kind of employment rights requires somebody going to the Netherlands, from Canada to do arbitration. That might be an example as something restricting or making enforcement subject to onerous obligations. B, excluding or restricting any right or remedy in respect to the liability. Restricting not the rights, but the damages or injunctions or the other remedies that you can get that would uphold the right. And then excluding or restricting rules of evidence or procedure, to put grit in the wheels of the process. And to the extent that sections 2, 5 to 7 also prevent excluding or restricting liability by reference to terms and notices which exclude or restrict the relevant obligation or duty. So that's saying that COOT is not being followed. It doesn't matter whether it's a duty defining clause or not, whatever that means. Section 13 makes sure that the unfair contract terms applies in effect to objectionable terms or unfair terms, not just the form. Now, we see that illustrated in another leading case called Smith and Eric Bush in 1990. So what happened here is that Mrs. Smith bought a new house with a loan from a building society. And the building society hired Eric S. Bush to do a survey, to see whether basically the building was going to stay standing or not. And the survey reported that there were no essential house repairs needed. However, this was a little bit different than a straightforward contract because Eric S. Bush did not contract with Mrs. Smith, who got the house. Eric S. Bush did a report for the building society, so that's where the contract is. But then it also had what amounted to an exclusion clause, which is that it disclaimed that it had, or that it warranted any accuracy of the report to anyone who might ultimately read the report. Right, so this isn't a straightforward exclusion clause in a contract between two parties. It's saying that I don't have any duty to anybody in a contract that I make with one party that then obviously gives on the survey to another party, the person who's obviously interested in relying on whether the report is right. So after Mrs. Smith bought the house, unfortunately the chimney collapsed and destroyed the roof. And the question was whether Eric S. Bush was liable given the Unfair Contract Terms Act, Section 2.2, because this is property damage, and Section 13. So the House of Lords holds that, yes, Eric S. Bush is liable because under Section 13.1, the attempt to preclude the duty had no consequence. And that meant that the clause was caught by Section 2.2. And then you go on to ask, well, is this duty denying clause reasonable under Section 11? And the answer that the House of Lords gave is no, because, very simply, Eric S. Bush was in a better place to get insurance than Smith. So the judgment, and in particular Lord Griffiths, says the following. Lord Griffiths says, everyone knows that all prudent professional people carry insurance, and the availability and cost of insurance must be a relevant factor when considering which of the two parties should be required to bear the risk of loss. So again, we're asking who is the better placed party to get an insurance contract. We're dealing, says Lord Griffiths, in this case with a loss which will be limited to the value of a modest house and against which it can be expected that the surveyor will be insured. We would expect, he's saying, that insurance should be gotten by the party who's doing the survey, not the person who's the homeowner, because, he goes on, bearing the loss will be unlikely to cause significant hardship if it has to be borne by the surveyor. But on the other hand, it's quite possible that it will be a financial catastrophe for the purchaser, who may be left with a valueless house and no money to buy another. So the consequences for the individual home buyer can be proportionately much, much bigger, so better that the law protects them through the unfair contract terms legislation. Okay, so another example of Section 2.2 and Section 13 is called Phillips Products Limited and Highland. And here we see Hampstead Plant Hire hiring out a JCB excavator. So that's one of these sort of yellow things, with a big sort of digging stuff, maybe it's got a mechanical claw, a JCB excavator. And with your JCB excavator, you also get a driver, who in this case is called Mr. Hyland. So this is being hired out to Philips Products Limited. Now, standard form contracts in the industry had something called Condition 8, which said that the driver, in this case Mr. Hyland, would be considered to be the employee of the person hiring the vehicle. So that's the employee of Philips Products. And unfortunately, this all went wrong because Mr. Hyland crashed into a wall, causing damage. So the question is whether Hampstead Plant Hire is liable for the damage, yeah, because it's hired out Mr. Hyland and given the JCB excavator, or Philips Products has to bear the loss because Condition 8 says that, well, if I hire, if I give you this JCB excavator and the driver is your employee, they're your responsibility. So that means the damage caused to the crashed wall is a risk that you have to bear. So in the Court of Appeal, Lord Justice Slade decides that Condition 8 was in effect an exclusion clause. It's not just something that's transferring risk and defining the duty. In effect, it doesn't matter what the form is. It's an exclusion clause, even though it was in the form of shifting responsibility onto Philips Products for whatever supposedly their driver did wrong. And it was caught by Section 13. So then the question becomes, well, is it reasonable under Section 2.2 because it's property damage? And the answer, said the Court of Appeal, is no. It's not reasonable because Hampstead Plant Hire was better placed to get insurance for such short hire jobs. Now, I think it's important to see that this is a context-dependent decision, and if you change the facts around slightly, the courts can and do come to different results, depending on who the impact of the exclusion clause ends up being placed upon. So in this case, Thompson and T. Lohan Plant Hire Limited, we see exactly the same Condition 8, exactly the same contract term, but in a different setting. So here, T. Lohan Plant Hire had hired out a JCB excavator and a driver, also Mr. H, but this time Mr. Hill, to a company called JW Hurdis Limited. So Condition 8 again says that the drive is yours, that Mr. Hill would be considered to be JW Hurdis Limited's employee, and then very sadly, tragically, Mr. Hill ran over and killed somebody called Mr. Thompson. Now, Mrs. Thompson is very sad, of course, a tragic death of her husband. She sues T. Lohan Plant Hire and wins compensation. Right, so she gets damages for the death of her husband. But then T. Lohan Plant Hire seeks to get the money back from JW Hurdis. So the question is whether Condition 8 is effective and who needs to pay. But the difference in this case is that the victim of the damage, who is Mr. and Mrs. Thompson, has already been compensated. And the Court of Appeal holds that because the victim is being compensated, or I think at least that's relevant, the point of Section 2.1 is to protect the victim, Section 2.1 in this case, but because Condition 8 has past liability to JW Hurdis and it operates between two business parties, and the victim's not compensated either way, Condition 8 shouldn't be considered to be an exemption clause that is unreasonable. Mr. Hurdis was, in this case, to be considered as JW Hurdis's employee. Now, I think you could have actually come to the same result in this case through a different mode of reasoning. You could have said that actually this is an exemption clause, but after saying that it's caught by Section 13, that you say that it's reasonable because of the balance of the risk between the parties. So they could have come to the same result through different reasoning. So I think that might be something to argue about. Now, moving on to Section 3 of the Unfair Contract Terms Act. Again, we've got a slightly different subject matter. So Section 3 is about liability for breach of contract. So when somebody deals on another person's standard terms, this is in subsection 1 of the of Section 3 of the 1977 Act, when somebody deals on another's standard terms, then under subsection 2, there can be no exemption for liability for breach of contract or performing something that was different from what was reasonably expected or performing nothing at all unless the exemption clause is reasonable. So unlike section 2.1, but like section 2.2, section 3 is saying that you can have exemption clauses so long as they are reasonable. Yeah? And then, of course, we've got to go to the reasonableness test in section 11 and schedule 2. Now, a really good example of this, and I think a leading case as well, is in the Court of Appeal called Time Load Limited and BT PLC. So here, BT's clause said that it could terminate a contract at any time, like really at any time. And this was used in a way which Time Load Limited felt was very unfair because it meant it didn't get continued supply for its telecommunications services. So Thomas Bingham, Master of the Rolls, held that this term was unfair. So they are purporting the right to cancel the contract or cancel performance of the contract at any time that's performing something which is very, very different from what is expected. And that's why it's unfair. It's rendering a contractual performance that's different from what is reasonably expected, and that's a stable service. So I just pause to note at this point that this is the second big case that we've seen from, well, the Court of Appeal now, and before there was the House of Lords in George Mitchell and Finney Lockseeds, where very clearly you've got small businesses, or in this case medium businesses, benefiting from the unfair contract terms legislation. And that's very different from what Lord Neuberger and what Lord Sumption said in Parking Iron Beavis, saying that the Unfair Contract Terms Act has for the most part been superseded by the consumer protection legislation. Doesn't seem to be true at all, because George Mitchell was about a small business, in the cabbages. This case, Time Load, is definitely about a small or a medium business contracting, with a big quasi-monopoly BT, and it's an example of how important unfair terms regulation can be to protect small and medium enterprises. Now let's go on with some more examples from section 3. This case, called Stuart Gill and Horatio Meyer in the Court of Appeal, was about the following. Stuart Gill sold Horatio Meyer an overhead conveyor system, so that's something that carries things probably along some wires. It sells an overhead conveyance system, and Horatio Meyer was supposed to pay the price of the conveyance system in installments. Stuart Gill's condition 12.4 excluded Horatio Meyer's right to set off payment for goods being defective. So if the overhead conveyance system didn't work, then it's saying in clause 12.4 that you have no right to set off your payment in installments if it turns out that the stuff doesn't work. And then, of course, lo and behold, and this is why we've got a contract case, it doesn't work. And Horatio Meyer refuses to pay the last installment. Stuart Gill sues, and it says, well, you can't withhold payments because we've got condition 12.4. The Court of Appeal holds that section 13 means that condition 12.4 is in effect an exclusion clause, and then it's also caught by section 3, and it's unreasonable. So it's not okay to just say that that the right of set off is excluded, particularly because you're dealing with parties that are potentially of unequal bargaining power. And also, I should say, obviously, if I'm selling you something that doesn't work, it seems pretty cheap that I can then try and wriggle out of my remedies for your product not working. Now, here is another big case, or very important, I suppose, politically in the Court of Appeal. And in this situation, it's not, a big business and a small business, but it's a big business and a public authority. And again, very unequal bargaining position. So this is called St Albans City and District Council and International Computers Limited. So that at the time was one of the biggest computing corporations in the world. And it involved Margaret Thatcher's Conservative government wishing to put a poll tax on people, also known as the community charge. So the basic idea They tried this in the Peasants' Revolt of 1381, and Margaret Thatcher thought it would be a good idea as well to essentially make people pay taxes for the privilege of being alive. So before riots forced the poll tax to be scrapped, and this ultimately ended up with Margaret Thatcher being removed from office by her own party, councils like St Albans had bought computer systems to administer the poll tax, to set up systems to collect data and figure out how much needed to be paid by which residents. But then St Albans' computer system failed, the one that it bought from International Computers, and that meant that it lost a lot of money in lost tax collection, amounting to around £1.3 million. The problem that it faced is that International Computers Standard Terms limited liability for any losses to £100,000. So, that's a very significant limitation clause. Is it fair? The answer is no, it's not. Justice Scott Baker, held that the limit was unreasonable under sections 3 and 11 and Schedule 2, and the main reason was that International Computers had much more resources, much more bargaining power. Even though the St Albans District Council is a government entity, it's a relatively small government entity, and I think that speaks something very important that big multinational corporations, now think of Microsoft or Apple or Google or Amazon, really do have much more bargaining power than even nation states sometimes, particularly when they're bargaining in a normal contractual setting. Okay, a few more examples before we begin to wrap up. This case is called Watford Electronics and Sanderson Limited. And I think that you're starting, I hope at least, to see a pattern in the way that these cases go. You just have the statutes, and then again and again we get illustrations of how they are applied. So, you don't need to sort of memorize all of them, but understanding how they work and understanding the patterns is the important thing. So this one gives us another important principle, which is just as, if the parties have very unequal bargaining power, that's going to make clauses more unreasonable. This tells us when parties have more equal bargaining power, clauses are likely to be considered reasonable. Yeah. So in this case, Sanderson was a software supplier, and Sanderson sold Watford Electronics, which was a computer retailer, a computer system, and like in St Albans, it failed. And again, the contract stated that consequential losses would be excluded. So that's putting a very, very low limit because it's not just the price of the thing that you're buying, but any lost profits that result from business losses when your computer systems fail are being exempt from liability in the contract. So the question for the Court of Appeal is whether there is a claim. Lord Justice Chadwick held, overturning the judge in the High Court below, the following. He said that in circumstances in which the parties of equal bargaining power negotiate a price for the supply of a product under an agreement which provides for the person on whom the risk of loss will fall, it seems to me that the court should be very cautious before reaching the conclusion that the agreement which they have reached is not a fair and reasonable one. So this term is not unreasonable, and the main reason is that the parties have more or less equal bargaining power. So, I think that speaks to a very important idea in commercial law, that when you've got two big businesses of equal bargaining power, when you've got two small businesses of equal bargaining power, or two medium businesses of equal bargaining power, the court shouldn't be using the unfair contract terms legislation because the parties should be able to come up with the contractual allocation of risk that they think is best. That, of course, is not applicable when we've got a big corporation dealing with a very small business, or even a medium business dealing with a small business. That is when it's more legitimate for the unfair contract terms legislation to come in, because freedom of contract ceases to exist in reality. Then there's First Tower Trustees Limited and CDS Superstores International in 2018, so a more recent case. CDS claims that First Tower Trustees Clause 5.8 in its lease agreement is unfair, and well, what did it do? It excluded liability for misrepresentations. First Tower Trustees said there was specifically, the misrepresentation. There was no environmental problems in its warehouse, but unfortunately, there was the very opposite of no environmental problems. The warehouse was infested with asbestos, which is that sort of toxic substance used to insulate against fire. It used to be used, hopefully not anymore. And if asbestos fibers get into your lungs, you have a very slow and painful death, unfortunately. You'll see lots more about that in tort law. So the question here is, under the Misrepresentation Act of 1967, Section 3, which says, remember back to last term, it says that any exclusion and misrepresentations are subject to the reasonableness test. And under Section 11 of the Unfair Contract Terms Act, is this exclusion for liability for misrepresentation effective? And the answer is no. So the Court of Appeal says, Lord Justice Lewison says that the misrepresentation could not be excluded. First Tower Trustees would have been liable but for the exclusion, and the exclusion isn't reasonable because First Tower Trustees is better placed to get insurance. So you can see that bargaining power comes up a lot in the case law. Insurance comes up a lot in the case law. Who has the better contractual allocation, or who is better placed to bear the contractual allocation of risk. So here you've got two businesses. Misrepresentation, exclusion is not effective because it counts as unreasonable. Okay, so that's First Tower Trustees and one of the most recent cases. Now, then I think we also should just mention very briefly Section 10. This is about separate contracts, and it says that contracts that take away rights from a first contract have no effect. So if you've got a primary contract and it's supplying goods or services or anything else, and then you have another contract over here which purports to restrict the right to anything in this contract, then that is of no effect. In other words, it just puts the two contracts together and they're treated as a whole. Again, this is sort of like an anti-avoidance provision like Section 13. But Tudor Grange Holdings and Citibank says that Section 10 doesn't apply to genuine compromise agreements of existing claims. So that would be, for instance, if I've sued you under the Unfair Contract Terms Act and we've debated about whether we should go to court and how much you owe me or not, and then we decide to settle in advance of going to court, then that compromise agreement isn't rendered void by Section 10. So you can still settle your cases. So this is outside. Section 10 is for things outside the ordinary process of litigation. So let's summarize all of that. UCTA 1977 isn't a scary statute at all. It's actually got a really simple structure. And it can be seen very simply by just looking at the different functions of what each section does. So first of all, Section 2.1 says that any exemption for liability for death or personal injury is void. Really simple. Section 2.2 fastens on property damage, and it says that you can not have exemptions if the exemptions are unreasonable, but by the same token, you can have exemptions if they're reasonable. And that points us to Section 11 on insurance and Schedule 2 on bargaining power and transparency and the rest. Then there's Section 3, which says that exemption of liability for breach of contract in standard form contracts must be reasonable. So same test, Section 11, Schedule 2. And Section 6 says that exemption of implied terms under the 1979 Act must be reasonable, and again, Section 11, Schedule 2. And just a little footnote is that the term that you own title to something that you sell, if I sell you this pen, that becomes a mandatory term in all cases. And then Section 11, Schedule 2 has the reasonableness test, of course, and the court has to evaluate the following. Which contracting party is better able to get insurance for contractual risks, then the party's relative bargaining strength, then whether there's an inducement to agree, if the customer ought to have known of the term, the transparency, whether it was reasonable to expect compliance with conditions, or if the goods were made to special order. And that, ladies and gentlemen, is the Unfair Contract Terms Act. Now, let's just talk very briefly about reform of the Unfair Contract Terms Act. I think that the durability of the legislation suggests something to you about, probably how successful it's been, and the fact that we don't have a massive number of cases. There are cases, but they're not that often brought. Probably points maybe to its success. So ideally, if legislation and legislative rights work really well, then the parties are not encouraged to go to court. They're encouraged to settle beforehand because everybody knows what their rights are, and ideally, people aren't using unfair contract terms. Nevertheless, there is some criticism of the Act, so let's look very briefly at that. Probably the best article on this was not too long after the Act was drafted back in 1988. So Adams and Brownsword argue that under the unfair contract terms and under the George Mitchell and Finney Lockseed's approach, trial judges are probably left with too much discretion about whether there are unfair terms or not. So one downside could be for commercial agreements being overturned and interfered with too much. So remember, George Mitchell says that we should be deferential to the courts lower down the chain, and the first instance courts, we shouldn't overturn their findings of fact too easily. And they say that perhaps this gives too much discretion to the courts and that interferes with commercial certainty. So what they suggest is a remedy, and in fact this is probably followed to some extent, and you see that in Chadwick and Watford, is that, I beg your pardon, Lord Justice Chadwick and in Watford, is that they say that we should leave the parties' agreements alone, we shouldn't interfere with them, so long as they have equal bargaining power. I suppose then the question that follows on is, well, what if the parties don't have equal bargaining power? What should be the proper guide to dealing with unfair contract terms in those cases? And is there anything that we can do about the inherent discretion that judges have at first instance? And an alternative way that you might look at it is that you might say that under the Unfair Contract Terms Act, instead of just dealing with exclusion clauses and protecting rights indirectly, what Section 3 does is it says that if you depart from people's reasonable expectations, then you can't have an exemption clause unless it's reasonable. You could frame this in a positive way. You could say that there is a positive right to have your reasonable expectations being fulfilled. That's not what we've got in the law at the moment, but it could be one way of reforming the law. And along with reasonable expectations, you could fasten on to what the relevant right is at hand. So instead of the negative formulation of the 1977 Act as it is now, we could turn it upside down. So for instance, in Section 2.1, you say that there's a positive right to life and to safety. You could flip around Section 6 and you say that there are positive rights to satisfactory quality. And instead of defining when exemption clauses are void, you have a more constrained set of instances about when exemption clauses are valid. You could have positive rights to fair and open dealing or good faith, analogous to the situation in Time Load, where they don't want their expectations to service being varied. But more broadly, we could enact, and we don't have it yet, but we could enact positive rights to fair competition and freedom to conduct a business on fair terms. We could also deal with perhaps the problem of discretion by saying that and perhaps the indeterminacy of the reasonableness test by adopting a proportionality test. So the same as you see in public law or constitutional administrative law, where we ask a few different steps instead of the sort of broad holistic approach to reasonableness. We could ask, for instance, does the business have a legitimate aim in using an exemption clause? Are there grounds based on legitimate business interests, efficient administration, and the like to use an exemption clause? And then, if it has a legitimate aim, we ask whether the clause is appropriate, necessary, and reasonable between the parties. So, having a more targeted test drawing on public law. That's all up for debate, though. And as I say, the Unfair Contract Terms Act has lasted pretty well so far. Okay, so let's just conclude on the lecture as a whole. So my first main point is that fair terms are often about business survival. And as we will see next week and the week after, I think this has become increasingly important in the face of big tech monopolies and big business monopolies, like Amazon, like Google, whose power has been even more augmented in the COVID-19 pandemic. So we see in cases like George Mitchell and Timeload, there are decisions where the cases on unfair terms regulation really does save businesses prosperity and guards their survival. So George Mitchell, Timeload, First Tower Trustees, I think, and I would argue, are clearly correct decisions. They're not decisions as Lord Sumption, Lord Neuberger seem to have characterised them in Parking Eye and Beavis, as ones that should be superseded or somehow exceptional or should somehow be relegated to history. They're a fundamentally important part of regulating fair enterprise in the modern economy. But the third main point that I have is that this is just a start. There also needs to be a broader law of enterprise in which all of this unfair contract terms regulation is embedded in. So that means public ownership sometimes, or the regulation of monopolies wherever they exist, and aggressive competition law enforcement. So if you come and do enterprise law with me in a year or two, then we'll talk a lot more about that. But the fundamental point is that unfair terms regulation is the baseline for fair enterprise. It should set a floor of minimum rights that make enterprise law work for everyone. Okay, so that is all for today. However, we have some homework. I asked you to do some homework and send in some unfair contract terms that you had seen around. So a whole group of people, you sent in some fantastic things, and I don't have time to show them all, but I said that I'd show you a selection. And what I want us to think about is what the law might do, if anything, about terms like this, because I guarantee you, once you start looking, you will find them everywhere. So I'm not going to read out names because we're also on YouTube, but thank you to everybody who sent these terms in. The first one I thought was really funny was about golf ball damage, and I'm wondering whether this is a certain outside of a certain ex-president's golf course. I don't know where it is, but it says beware of golf balls for 3/4 of a mile. It could be that one in the north of Scotland. And golf club and golfers cannot be held responsible for damage to illegally parked vehicles. Well, that sounds pretty unfair if the golf ball has been negligently hit. On the other hand, if you are on private property, it might be arguable that that this sort of exclusion clause is valid. It would depend, and I'd be interested to know what you think about it. It's probably section 2.2, unless you can think of anything else. Now, the second one, which I thought was great, was somebody sent in this screenshot of iCloud. So this says, welcome to iCloud, where you store everything. And of course, Apple wants you to store absolutely everything on iCloud because then it can get your data right. But then when it's storing your stuff on iCloud, it says, when it begins with the underlines, I don't know if you can see my... perhaps you can see my cursor there. Apple does not represent or guarantee that the service will be free from loss, corruption, attack, viruses, interference, hacking, or other security intrusion. And Apple disclaims any liability relating thereto. And in the end, it also goes on to talk about death, personal injury, or severe damage. Now, I don't think that this would be valid in any way in EU law or UK law for several reasons. Because essentially they're purporting, in relation to consumers or to whoever, to not have any liability for breach of contract. So that almost certainly would be subjected to Section 3 and probably be held to be unreasonable under Section 11 and Schedule 2. Now, then there's this one, which I'm really grateful to the person who sent this in. This is somebody who's got a job at Deliveroo, and the Deliveroo contract says essentially, well, they're trying to deny that the Deliveroo cyclists are their employees or that they have any responsibility. So if you come and do labour law with me and Professor Ewing next year or the year after, we'll go into lots more stuff like this. I'm sure all of you, or many of you, have Deliveroo on your phone or Uber Eats or Just Eat, and you've seen how tired and how hard the cyclists work. The big problem is that, although these apps are very efficient pieces of software, the companies try to deny that they have any duties towards their staff. So not paying the minimum wage, not paying for holidays, not paying for healthcare coverage in the United States or in Canada or in the UK, protection for workplace accidents. They get the drivers or the cyclists to get their own insurance. And as this one highlights, what it's trying to do here is it's trying to say in Clause 2.2, you're not obliged to do any work for Deliveroo, nor is Deliveroo obliged to make available any work to you. And this is a way, it's a little bit tricky, but it's a way of saying that there's no mutuality of obligation as a mechanism to deny that you've got an employment contract or that you're an employee and therefore get any employment rights. But again, I think that it wouldn't be the unfair terms legislation, but I think it would almost definitely violate a number of statutory rights, in particular in the Employment Rights Act 1996. And if you want to read what I've written about this, there's that article about Uber and mutuality and the duty to not misrepresent employment status. We'll be seeing a couple of cases in the Court of Appeal and Supreme Court coming up hopefully soon. A fourth example, somebody has their own cake business, which is amazing. So this is an example of somebody who's running their own cake business, and they got the cakes to be delivered to one of their customers. And the delivery company, I don't know whether it's Deliveroo or somebody else, but again, a sort of cutthroat delivery company is saying that if anything happens to fragile cakes, then we're not responsible for anything. So I know it's a bit blurry, but it's in this clause in the terms of service too. The items for delivery are not, you've got to warrant, of the following nature: fragile items, including cakes. But then what the person who sent this to me has pointed out is that when you order the delivery services, it actually lets you click a box saying whether the things are fragile or not. So give us your fragile cakes, but we're not going to protect them if you do, which seems to me to be problematic, to say the least, under Section 3 of UCTA, because you're promising one thing and then doing another. And just finally, this is actually from a previous year, not one that you sent in, but from King's Residences, and an awful term, an absolutely appalling term, where it says that King's Residences supposedly has the right, there I've underlined it, to enter accommodation at any time, including during the night, without giving you notice. So this is obviously a violation of the human right to privacy. Countless or numerous parts of the Landlord and Tenant Act, they'll probably claim that you're a licensee, but really they should be having a court order in order to invade your private home. But there we go. That's in the King's Residence Agreement, and something should be probably done about it. Now, last thing was a personal favourite of mine. It was actually from a couple of years ago. But this clause says, and I guess it's for people going onto property, danger, private lot, outsider, no enter. If any accident, take yourself. So I guess that's a sophisticated way of saying we're not liable for any kind of death or personal injury.